June of last year was a month that would go down in infamy, when 5 members of the Supreme Court chose to be extremists, and they chose to tear apart the Voting Rights Act that was dipped in blood and won in Selma 49 years ago. They chose to suggest that there was no longer need for federal coverage and federal inspection at the state level. That was a tragedy. Immediately following, states began to pass, like North Carolina, the worst voter suppression we've seen since Jim Crow, which is proof that we still need federal oversight. Now the Congress has decided bipartisanly to consider a bill, which is a good step, but the problem with it is it leaves out North Carolina and Alabama and Florida and other critical states, South Carolina and Virginia, and it doesn't expand Tennessee, and it doesn't expand coverage. And so we're going to say to the United States Congress that that is insufficient, that we don't need a bill that just simply manages a little bit of discrimination. We need federal oversight of our states because we have extremists in our state capitals that are trying to roll back voting rights. And when they roll back voting rights, they hurt us all. They hurt us black, they hurt us white, they hurt us Latino, they hurt us young, they hurt us poor. And when President Johnson signed the Voting Rights Act of '65, he said it was a victory greater than any victory we've ever won on any battlefield. But almost 48 years later, on June the 25th, 2013, June 25th, 2013, the same day that in 1773 slaves first petitioned the state of Massachusetts for their freedom. On June 25th, a day that once represented a glorious day in the struggle for liberation, it became a day of infamy. Because on that day, 5 Supreme Court justices dismantled the Voting Rights Act. And they in essence said to Southern legislators, led by extremists like ours, now that your state does not have to worry about pre-clearance, does not have to worry about voting laws being reviewed, you can initiate and inaugurate a new season on voting rights. You can roll back and suppress the right to vote. And since the days of deconstruction in the late 1800s, when Southern Dixiecrats sought to pass and did pass laws that would abridge the rights of the newly freed black people and undermine their power, since those days, we've not seen an attack on voting rights and an attempt to abridge the right to vote like we've seen right here in North Carolina. Right here. When in August of 2013, House Bill 589, say it, I don't ever want you to forget it. House Bill 589, that was first filed in the General Assembly on August the 4th, 2013. April 4th, 2013. Thank you, the anniversary of the assassination of Dr. King. And that bill, after Shelby on the 25th of June, became the worst and the first voter suppression bill after Shelby. It went from 14 to 57 pages of voter suppression. And they did it without any debate, without any hearings. They nearly passed it and a governor signed it. And when they did, this legislature and this governor instituted another season of what Dr. King called in '63 interposition and nullification against our rights.
George Wallace's rationale for interposition and nullification sounds strangely similar to what our government is saying now about this decision.
Right now?
His response also sounds strangely similar to Donald Trump.
Right now.
Listen
Right now.
But I want to tell you why. Because what Donald Trump does is when you can't debate the substance, you attack the judges. George Wallace engaged in interposition and nullification. That is a refusal to accept the ruling of a higher court. Now, the jurists in this case, and I want North Carolina and America to hear this, are above reproach. we've heard in recent days that these were Democratic jurors and they were doing this to help Hillary Clinton. We didn't pick the judge. The jurors are above reproach. In fact, the judge who wrote the opinion, just Perry, the judge who wrote the opinion in the final part was against us when we first went to the federal court.
Look at it.
The same judge that wrote this opinion dissented when we asked for a temporary injunction. Huh? Now, once she got the whole record, she wrote this unanimous report.
Your legal team has drawn its direction, its course of action, and its moral compass from your leadership. The plaintiffs and membership of this organization would not accept open, targeted rollbacks to African American and Latino voting rights in 2013. You would not accept it in 2014.
Would not.
You would not accept it in 2015.
Would not.
And in 2016, we can celebrate this victory. I want to take one moment to remember the last time that I was in this church. And that was during a massive Moral Mondays campaign led by this coalition that cried out prior to the passage of this law to say, don't do it. This is wrong. The legislature did not listen then, but they must listen now. In the words of the Fourth Circuit victory, although the new provisions target African Americans with almost surgical precision, they constitute inapt remedies for the problems assertedly justifying them, and in fact, impose cures for problems that did not exist. We have heard this before, and we've heard it from you. Within 1 hour of the governor's signature being affixed to this bill, the North Carolina NAACP filed a constitutional challenge and a challenge under the Voting Rights Act Section 2, calling out the precise reasons that the Fourth Circuit has just ruled in your favor. And that was intentional discrimination and the effect of this law on African Americans and Latinos in this state, and all North Carolinians.
This decision was unanimous.
Justice.
Unanimous. And to suggest that these jurors, 2 white, 1 African American, conspired for partisan reasons is in essence our governor saying they are corrupt, they are deceitful, and they are operating in contempt of the Constitution.
Make it plain.
And for a sitting governor and legislature, but for a sitting governor to suggest that these jurors who are above reproach in the Fourth Circuit operated for any other reason but according to the Constitution is troubling.
Yes.
It is deeply concerning.
Look at it.
And it should give all North Carolinians pause regarding his leadership.
Look at it.
Because in the 21st century, the best you can do in the public square is to use the rationale of George Wallace.
Some wrong. Some wrong.
And the irrationale of Donald Trump.
Some wrong. Mighty wrong. Some mighty wrong.
I'm just saying.
Mighty wrong.
Now, the case was a sea change. It's the biggest case in the last decade, the biggest case since Shelby. It sends shockwaves through the halls of jurisprudence about where we stand in terms of voting rights. The second highest court in the land found that Governor McCrory, the case was in NC NAACP versus McCrory, never forget that, and other leaders of the North Carolina legislature intended. This is the highest standard in the law. Intended to discriminate against African American and other voters. Intended of color as they wrote these laws, knowing that they would have a disproportionate impact. This is unconstitutional.
I mean, to follow up on what Reverend Barber says, this decision means Shelby County was wrong. Chief Justice Roberts implied we live in this post-racial society where voting discrimination on the basis of race doesn't exist. It does. And the Fourth Circuit Court of Appeals unanimously agreed. So my big point here is going to be urge vigilance. We can't give up on the Voting Rights Act. We can't give up on demanding the Voting Rights Act be fully restored. But now we're going to see the fruits of our victory in the election in November, and we can't let our guard down. Vigilance is demanded. So there's a few things we need to do. On Monday and Tuesday in Concord, North Carolina, the State Board of Elections will be training all 100 county boards of elections on the new election laws. We will be there. We will be demanding that they're accurately reflecting what the state of the law is, what the spirit of the law is, and the spirit of the law is this. Voting opportunities are restored to the way they were before this discriminatory law.
There are ongoing challenges that we have to face. And as we speak here today, there is a caravan of cars headed to Washington, D.C., led by the attorneys for McCrory, the North Carolina General Assembly, and the State Board of Election to file a petition for certiorari with the U.S. Supreme Court. So while we are gathered here today, they are working to undermine everything that has occurred. I want you to understand that. They are working at this very moment to undermine what has occurred.